ವಕಾಲತ್ತಿನ the advocate profession ಮುಂದಿನ ಭವಿಷ್ಯ ಏನು ಸರ್?
ಮುಂದಿನ ಭವಿಷ್ಯ is amazing. Today technology has transformed this profession completely.
Artificial intelligence.
Artificial intelligence is the next step. As it is today, technology has contributed so much to our efficiency, especially the younger lawyers are able to use technology with ಎಷ್ಟು ಸುಲಭವಾಗಿ ಅವರು ಕಂಪ್ಯೂಟರ್ ಯೂಸ್ ಮಾಡ್ತಾರೆ. ನಾವು ಪುಸ್ತಕ ನೋಡಿ 1 ಗಂಟೆ ಕಾಲ ಮಾಡಿ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ತೊಗೊಳ್ಳೋದು, ಅವರು ಇವಾಗ 5 ನಿಮಿಷ ತರಿಸ್ಕೊಡ್ತಾರೆ ನಿಮಗೆ. ಬಟ್ ಹ್ಯಾವಿಂಗ್ ಸೆಡ್ ದ್ಯಾಟ್, there is one danger one has to be very careful about. Technology should be our servant. Technology should not become our master. Technology should not supplant our intelligence. Technology should supplement our intelligence. You see, I give you an example today what happened. That is where technology is a very useful thing. It is that I think, according to me, gives a very bright future for the legal profession, like it has given for the medical profession or any other profession for that matter. So we are not lagging behind. Now, the only thing is, because we are a profession based upon knowledge and it is knowledge oriented, you have to acquire the knowledge yourself. You can't depend upon the knowledge which exists elsewhere. ಬೇರೆ ಕಡೆ ಇರೋ ಜ್ಞಾನ ಪ್ರಯೋಜನ ಎಲ್ಲ ನಿಮ್ಮೊಳಗೆ ಇರಬೇಕು. ಅದನ್ನು ಹೇಳ್ತಾರಲ್ಲ, ಪುಸ್ತಕದಲ್ಲಿರೋದು ಮಸ್ತಕಕ್ಕೆ ಹೋಗಬೇಕು. ಹಾಗಿರ್ಬೇಕಾದ್ರೆ ನಾವು ಓದಬೇಕು. ಜಡ್ಜ್ಮೆಂಟಲ್ಲಿ ನಾನು ಒಂದು 4 ಪದ ಹಾಕ್ತೀನಿ, SCC ಆನ್ಲೈನು ಅಥವಾ ಮನುಪಾತ್ರನೋ ಯಾವುದರಲ್ಲೋ ಒಂದು 4 ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದು ಅದನ್ನು ಕೋರ್ಟಲ್ಲಿ ಕೊಟ್ಟೆ ಅನ್ನೋದು ಬಹಳ ಇಟ್ ಈಸ್ ರಾಂಗ್, ಬಹಳ ತಪ್ಪು ಅಂತ ಮಾಡೋದು. ಫ್ಯಾಕ್ಟ್ಸ್ ಓದಬೇಕು. ಯಾವ ಫ್ಯಾಕ್ಟ್ ಸಿಚುಯೇಷನ್ನಲ್ಲಿ ಆ ಕೋರ್ಟು ಹೀಗೆ ಯಾಕೆ ಹೇಳಿದ್ರು ಅದನ್ನು ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು. ಆಮೇಲೆ ನಾವು ಅದನ್ನು ಕೋರ್ಟ್ ಮುಂದೆ ಕೊಡಬೇಕು. ಕಂಪ್ಯೂಟ್ರಲ್ಲಿ ಬಂತು ಅದನ್ನು ಕೋರ್ಟ್ ಅದು ತಪ್ಪು. So therefore, is there a bright future for this profession going forward? Of course, yes. Why? There is another reason. Today, with technology, information is available at the click of a button.
Fingertips.
And you therefore have the opportunity of seeing what is happening all across the world. You know how legal practice is shaping in America, how legal practice is sharing in Europe, how it is in England, how it is in Australia. Now, and you are competing with all those lawyers. Therefore, today your exposure is much better than the exposure it was when we started our profession. Next, you have greater opportunities of education. Books are available easily. Magazines are available easily. The legal literature is available easily. Everything is available in the computer today. So, you have access to knowledge. ನಾವು ಪ್ರಾಕ್ಟೀಸ್ ಶುರು ಮಾಡಿದಾಗ ಒಂದು ಫಾರಿನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬೇಕು ಅಂದರೆ ಅದನ್ನು ತರಿಸೋದಕ್ಕೆ ಒಂದು ದೊಡ್ಡ ಪ್ರಯಾಸ ಆಯಿತು. ಇವಾಗ ಏನೂ ತೊಂದರೆ ಇಲ್ಲ, ಎಲ್ಲನೂ ಇದೆ. ಸೊ ದೇರ್ಫೋರ್ ಪ್ರೊಫೆಷನ್ ಹ್ಯಾಸ್ ಗ್ರೇಟ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್. ವಿ ಹ್ಯಾವ್ ಟು ಮೇಕ್ good use of it. It is in your hands. Today you cannot blame anything. You cannot blame saying, oh, that facility is not there, this facility is not there, I am handicapped. No. And look at the good benefit that we have got out of the unfortunate COVID.
Correct.
Sitting in any area, in any part of the country, you can appear in any court. So today, a lawyer sitting in a Mafizal area, if he has got an internet connection, if he or she has an internet connection, can appear in the High Court here.
VC ಅನುಕೂಲ
ಆಗಿದೆ.
ಕೋವಿಡ್ ಇಂದ ಎಲ್ಲ ಅನುಕೂಲ ಅಂತ
ಅಲ್ಲ, ಅನ್ಫಾರ್ಚುನೇಟ್ ಕೋವಿಡ್, ದೀಸ್ ಆರ್ ದ ಗುಡ್ ಫಾಲೋಔಟ್ಸ್.
ಸರ್, ನ್ಯಾಯಾಂಗದಲ್ಲಿ ಬದಲಾವಣೆಗಳಾಗ್ತಾ ಇದೆ. ಇನ್ನು ಮುಂದೆ ಏನೆಲ್ಲ ಬದಲಾವಣೆ ಆಗಬೇಕು ಮತ್ತು ಏನೆಲ್ಲ ಬದಲಾವಣೆಗಳು ಆಗುವ ಸಾಧ್ಯತೆ ಇದೆ ಸರ್?
ನ್ಯಾಯಾಂಗದಲ್ಲಿ ಒಂದು ಬದಲಾವಣೆ ಆಗಬೇಕು. ದೇರ್ ಶುಡ್ ಬಿ ಎಕ್ಸ್ಪರ್ಟೀಸ್. ಇವಾಗ ನೋಡಿ ಏನಾಗ್ತಾ ಇದೆ. ಒನ್ ಜಡ್ಜ್ ಟುಡೇ, ವೆದರ್ ಇಟ್ ಈಸ್ ಇನ್ ದ ಹೈ ಕೋರ್ಟ್ ಆರ್ ಇನ್ ದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ಇಸ್ ದ ಸೇಮ್ ಪ್ರಾಬ್ಲಮ್. That judge, serial number 1 is some service matter, serial number 5 is some arbitration matter, serial number 10 is some constitutional issue, serial number 15 is some land revenue matter. There is no expertise. And the same judge this case he is doing a civil matter, next case it is a tax matter. I mean, everybody is not going to work. Therefore, we have to develop expertise. Therefore, every court, especially the High Court and the Supreme Court, must have divisions, according to me. You should have a tax division where judges are working only on tax matters, so that when a tax case comes before that particular judge, you don't have to tell him in the elementary things of tax law. He says, I know the tax law, I know all the judgments, because it has been repeated in front of me number of times. Nimma case facts heli saku nange. Illa tax ali section so and so is the charging section, this is the act.
Ella helbekku.
It's a waste of time. Company law, there must be expertise. Arbitration law, there must be expertise. So that they know ಅವರಿಗೆ ಕಾನೂನಲ್ಲಿ ಏನಿದೆ, ಯಾವ್ಯಾವ ಜಜ್ಮೆಂಟ್ ಬಂದಿದೆ, ಹೊಸ ಜಜ್ಮೆಂಟ್ ಏನು, ಹಳೆ ಜಜ್ಮೆಂಟ್ ಏನು, ಎಲ್ಲ ಗೊತ್ತಾಗೋಗುತ್ತೆ.
ಈ ಮೆಡಿಕಲ್ ನೆಗ್ಲಿಜೆನ್ಸ್ ಬಂದಾಗ ಇಟ್ ಇಸ್ ಬೆಟರ್ ಟು ಹ್ಯಾವ್ ಎ ಮೆಡಿಕಲ್ ಬ್ಯಾಕ್ಗ್ರೌಂಡ್ ಜಡ್ಜ್
ಹೂ ನೋಸ್ ಆಲ್ ದಟ್. ಅದು ಹೇಗೆ ಬರುತ್ತೆ, ಏನು ಅವ್ರು ಮೆಡಿಸಿನ್ ಓದೋ ಅವರು ಮೆಡಿಕಲ್ ಪುಸ್ತಕ ಓದಿರೋಲ್ಲ, ಬಟ್ ಕೇಸ್ ಮಾಡ್ತಾ 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 ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. That is how it should be, according to me. Therefore, ಸುಧಾರಣೆ ಹೇಗೆ ಆಗಬೇಕು ಅಂದರೆ there should be expertise. You see, lawyers is in no difficulty. The reason is this: the client will choose the lawyer.
Correct.
The client chooses the lawyer on the basis of the expertise. A judge sits for 2 months on one side, thereafter he is changed.
ಬೇರೆ ಚೇಂಜ್ ಮಾಡ್ತಾರೆ.
Now all the knowledge he has acquired ಆ field of law ಅಲ್ಲಿ ಅವರು ಏನೇನು ಜ್ಞಾನ ಗಳಿಸುತ್ತೆ ಎಲ್ಲ ಸುಮ್ಮನೆ ವೇಸ್ಟ್. ಇಟ್ ಬಿಕಮ್ ಸಮ್ಟೈಮ್ಸ್ ದೇರ್ ವಿಲ್ ಬಿ ನ್ಯೂ ಜಜ್ಮೆಂಟ್ಸ್, ಯು ವಿಲ್ ನಾಟ್ ಬಿ ಅವೇರ್ ಆಫ್ ಇಟ್. ಅಗೇನ್ ಯು ಹ್ಯಾವ್ ಟು ಸ್ಟಾರ್ಟ್ ದ ಹೋಲ್ ಥಿಂಗ್. ಅದಕ್ಕೆ ಟ್ರಿಬ್ಯುನಲೈಸೇಷನ್ಸ್ ಬಂದಿದೆ. ದ ಆಬ್ಜೆಕ್ಟ್ ಆಫ್ ಟ್ರಿಬ್ಯುನಲೈಸೇಷನ್ ವಾಸ್ ಟು ಪ್ರೊವೈಡ್ ಫಾರ್ ಸ್ಪೆಷಾಲಿಟಿ, ಬಟ್ ಆಫ್ ಕೋರ್ಸ್ ದೇರ್ ಇಸ್ ಮಚ್ ಟು ಬಿ ಡಿಸೈರ್ಡ್ ಇನ್ ದ ವೇ ದಟ್ ಟ್ರೈಬ್ಯುನಲ್ಸ್ ಆರ್ ವರ್ಕಿಂಗ್. Leave that aside, that controversy is a separate controversy. This is my answer to your question. ಮುಂದಕ್ಕೆ ಜುಡಿಷಿಯರಿ ಹೇಗೆ ಹೋಗಬೇಕು? ಯು ಶುಡ್ ಗೋ ಓನ್ಲಿ ಆನ್ ದ ಬೇಸಿಸ್ ಆಫ್ ಎಕ್ಸ್ಪರ್ಟೀಸ್. ದಟ್ ಈಸ್ ಹೌ ಐ ವುಡ್ ಥಿಂಕ್ ದಟ್ ಯು ಶುಡ್ ಡೂ ಇಟ್. ಆ್ಯಂಡ್ ದಿಸ್ ಟೂ ಮಚ್ ಆಫ್ ದಿಸ್ ಸೀನಿಯಾರಿಟಿ ಬಿಸ್ನೆಸ್ ಈಸ್ ನಾಟ್ ಗುಡ್ ಫಾರ್ ದಿ ಸೊಸೈಟಿ. ಇಟ್ ಶುಡ್ ಬಿ ಮೆರಿಟ್ ಬೇಸ್ಡ್.
ಈ ಔಟ್ ಆಫ್ ಕೋರ್ಟ್ ಸೆಟ್ಲ್ಮೆಂಟು, ಮೀಡಿಯೇಷನ್ಸು, ADR ಇನ್ನು ಮುಂದೆ ಹೇಗೆ ರೂಪುಗೊಳ್ಬೋದು ಸರ್?
ರೂಪುಗೊಳ್ಳಬೇಕು. ವಿ ಹ್ಯಾವ್ ಟು ಮೇಕ್ ಎನ್ ಎಫರ್ಟ್. ಅದಕ್ಕೆ ಆ್ಯಟಿಟ್ಯೂಡ್ ಆಫ್ ಪೀಪಲ್ ಮಸ್ಟ್ ಚೇಂಜ್. Litigation, especially frivolous litigation, must be nipped in the bud with heavy costs. ಆವಾಗ ಜನಗಳಿಗೆ ಭಯ ಬರುತ್ತೆ. ಓ ಇಲ್ಲಪ್ಪ ಸೆಟಲ್ ಮಾಡ್ಕೊಂಬೇಡ, ನಾವು ಟ್ರಯಲ್ಗೆ ಹೋದರೆ ನಮಗೆ ಭಾಳ ತೊಂದರೆ ಆಗಿಬಿಡುತ್ತೆ. ಆ ಭಯ ಇರಬೇಕು. ಇವಾಗ ಏನು ತೊಂದರೆನೇ ಇಲ್ಲ. ಜಡ್ಜ್ಮೆಂಟ್ ಈಸ್ ದ ಕೇಸ್ ಈಸ್ ಫ್ರಿವಲಸ್, ದ ಕೇಸ್ ಈಸ್ ವೆಕ್ಸೇಷಿಯಸ್, ಇಟ್ ಈಸ್ ಮ್ಯಾಲಫೈಡೆ. ಹೌಎವರ್, ನೋ ಆರ್ಡರ್ ಎಸ್ ಟು ಕಾಸ್ಟ್. ಯಾಕೆ? ದಟ್ ಈಸ್ ದ ಪ್ರಾಬ್ಲಮ್. If you want ADR to succeed, make litigation expensive.
More expensive.
Not expensive at the entry, but if you lose the case and the judge comes to the conclusion that this was not even a arguable case, come down heavily with costs. Entry point, don't make it expensive. Don't put ನಾನು 100 ರೂಪಾಯಿ ಕೋರ್ಟ್ ಫೀ ಕಡೆ 1 ಲಕ್ಷ ಕೊಡು, ಅದು ಮಾಡಬೇಡಿ. But at the exit time, leave it to the judge to impose heavy costs, and the judge must impose heavy costs. ಭಯ ಇರಬೇಕು. ಕೋರ್ಟಲ್ಲಿ ಬಂದು ಬಾಯಿಗೆ ಬಂದಿದ್ದೆಲ್ಲ ಮಾತಾಡ್ತೀನಿ ಅಂದರೆ ಭಯ ಇರಬೇಕು. ಆಗೋಲ್ಲ ಅಂತ, ಓ ನಾನು ಬಾಯಿಗೆ ಬಂದೆಲ್ಲ ಮಾತಾಡ್ತಿದ್ದರೆ ನನಗೆ ಜಡ್ಜು ಮಟ್ಟ ಹಾಕ್ತಾರೆ ಅಂತ. ದಟ್ ಈಸ್ ಮೈ ವ್ಯೂ.
ಸರ್, ವಾಟ್ ಈಸ್ ದ ಡಿಫ್ರೆನ್ಸ್? ವ್ಯತ್ಯಾಸ ಏನು ಸರ್ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಗೂ, ಡೆಸಿಗ್ನೇಟೆಡ್ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಸ್ಗೂ ಮತ್ತು ಅಡ್ವೊಕೇಟ್ಗೂ? ಲಾರ್ಜ್ಲಿ ವ್ಯತ್ಯಾಸ ಇಲ್ಲ. ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಗೂ ಜೂನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಗೂ ಕೋರ್ಟಲ್ಲಿ ಏನು ವ್ಯತ್ಯಾಸ ಇಲ್ಲ. ಈಗ ಜಡ್ಜಿಗೆ ಯಾರು ಅಪಿಯರ್ ಆದರೆ ಏನಂತೆ, ಎಲ್ಲನೂ ಒಂದೇ. ಬಟ್ ನಮ್ಮ ಪ್ರಾಕ್ಟೀಸಲ್ಲಿ ವ್ಯತ್ಯಾಸ ಇದೆ ನೋಡಿ. ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ಗೆ ಸರ್ಟನ್ ರೂಲ್ಸ್ ಇದೆ. ನೀವು ಕಕ್ಷಿಗಾರನ ಡೈರೆಕ್ಟಾಗಿ ಮೀಟ್ ಮಾಡಲ್ಲ, ನಾನು ಡ್ರಾಫ್ಟಿಂಗ್ ಮಾಡಲ್ಲ. ಇದನ್ನು ನಾವು ಸ್ಟ್ರಿಕ್ಟಾಗಿ ಪಾಲನೆ ಮಾಡಬೇಕು. ಇಫ್ ಯು ವಾಂಟ್ ಟು ಪ್ಲೇ ದ ಗೇಮ್, ಪ್ಲೀಸ್ ಒಬೇ ದ ರೂಲ್ಸ್ ಆಫ್ ದ ಗೇಮ್. ಅದರ್ವೈಸ್ nobody is compelling you to accept the senior advocate position. It is your voluntary act. ಅದು ಮಾಡಿದ ಮೇಲೆ ನಾನು ನೆನ್ನೆನೂ ಕಕ್ಷಿಗಾರನ ಮೀಟ್ ಮಾಡ್ತಾ ಇದ್ದೆ.
ಡೆಸಿಗ್ನೇಷನ್ ಆದ್ಮೇಲೆ ಅದೇ ಕಕ್ಷೆಗಾರನ ಮೀಟ್ ಮಾಡ್ತಾ ಇದ್ದೆ, ಏನು ಪ್ರಯೋಜನ? ದಟ್ ಈಸ್ ಒನ್ ಪಾಯಿಂಟ್. ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದ್ಯಾಟ್, there is one other important role that a senior advocate must play in his profession. ಏನಪ್ಪ ಅಂದರೆ, ನಾನು ಯಾಕೆ ನನ್ನ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ? ಯು ಹ್ಯಾವ್ ಟು ಮೂವ್ ಅವೇ ಫ್ರಮ್ ದಟ್ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ ಕಾಂಪಿಟಿಷನ್ and make place for the next generation to come. Let them come. I am moving away. Now I will restrict my practice to certain areas. I will be a counsel. I will only argue cases. ಮಿಕ್ಕಿದೆಲ್ಲ ನೀವು ಮಾಡಿ. ಕ್ಲೈಂಟು ನಿಮ್ಮ ಕ್ಲೈಂಟ್, ಅದು ನೀವು ಕ್ಲೈಂಟ್ ಜೊತೆ ಕೂತ್ಕೊಂಡು ಮಾತಾಡಿ, ಕ್ಲೈಂಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ನೋಡಿ, ಎವಿಡೆನ್ಸ್ ಏನೇನು ಬೇಕು ತೊಗೊಂಬನ್ನಿ, ನೋಡೋಣ. So you have to do your job as a advocate dealing with the client. If the senior advocate ಅದನ್ನೇ ಮಾಡಿದ್ರೆ ಎಲ್ಲನೂ ಒಂದೇ ಅಲ್ವಾ? ಯಾಕಾಗುತ್ತೆ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಆಗಿ? That is a very important distinction. There is another important distinction. You should not meet a client without an instructing counsel. That I think is a very strict rule one must follow. If the client can call a senior advocate and talk to him directly, ಅದೇನಾಯಿತು? You are bypassing the junior advocate. Why? You should tell the client, sorry, I will not meet you. Please come with the instructing counsel, then I will talk to you. I am not saying the senior advocate should not meet the client ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ. The client must come always with the junior advocate. In other words, junior advocate should not be bypassed. That is your duty to ensure that the client says, hey, ಅವ್ರು ಬೇಡ, ಇವರೇ ಸಾಕ್ತಂಗೆ. No, that should not be done. Third important distinction I will tell you, which is very, very important. You see, in a meeting where you have a conference with the client and the junior advocate who is instructing you may come up with a point. There are ways, maybe that point is totally frivolous, maybe something very critical has been missed in the case. There are two ways of handling it. Gently saying, ಇದನ್ನು ನೋಡ್ಬೋದಲ್ಲ, ಇದನ್ನು ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಬನ್ನಿ, ಇದೇನೋ ಒಂದು ಪಾಯಿಂಟ್ ಇರೋ ಥರ ಇದೆ. Though in your mind you may be clear that the point that the junior advocate is saying is absolutely wrong. ಒಂದು ನೈಸಾಗಿ ಹೇಳ್ಬೋದು, ಇನ್ನೊಂದು ನೀವು ಹೇಳ್ತಾ ಇರೋದಲ್ಲ ಬರೀ ತಪ್ಪು ಅಂತ ಹೇಳ್ಬೋದು. ನಾವು ಕ್ಲೈಂಟ್ ಎದುರುಗಡೆ ನೀವು ಹೇಳ್ತಾ ಇರೋದು ಬರೀ ತಪ್ಪು, ಅಥವಾ ಏನ್ರಿ ನೀವು ಈ ಥರ ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್ನ ಮಿಸ್ ಮಾಡಿಬಿಟ್ರಿ ಅಂತ ಕ್ಲೈಂಟ್ ಎದುರಿಗೆ ಹೇಳಿದ್ರಿ, the client will say, I have a very useless junior advocate, ಅವ್ರನ್ನ ಬೇಡ ಅಂದ್ಬಿಟ್ಬಿಡ್ತಾರೆ. ಮಾಡಬಾರ್ದು. We have to protect the interest of both the client as also the junior advocate. Therefore, what do? I have done it many times. When I find that there is something obviously wrong in the approach of the junior advocate, I don't say it in presence. After he has gone, I call him and say, ನೋಡ್ರಿ ಅದೊಂದು ಇಂಪಾರ್ಟೆಂಟ್ ಪಾಯಿಂಟ್ ಇದೆ, ಮಿಸ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದೀರಿ, ಅದು ಸ್ವಲ್ಪ ನೋಡಿಬಿಡಿ, ಅದನ್ನು ಇದು ಗ್ಲೇರಿಂಗ್ ಆಗಿದೆ, ಇದು ಲಿಮಿಟೇಷನ್ ಬಾರ್ ಆಗಿದೆ, ಹೇಗೆ ಹಾಕ್ತೀರಿ, ಇದು ಹೇಗೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದು? ನೀವು ಆ ಕ್ಲೈಂಟ್ ಎದುರಿಗೆ ಹೇಳಿಬಿಟ್ರೆ ಆ ಇರೋ ಕ್ಲೈಂಟ್ ಅವ್ನು ಹೊಟ್ಟೋಗ್ತಾನೆ. ಅದು ಮಾಡಬಾರ್ದು. ದಟ್ ಈಸ್ ದ ರೋಲ್ ಆಫ್ ಎ ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್. ಗೈಡ್ ದ ಜೂನಿಯರ್ ಅಡ್ವೊಕೇಟ್, protect the interest of the junior advocate, at the same time don't sacrifice the interest of the cause. See, plus your role in the court, you are not simply a channel. A junior advocate ಹೇಳಿದೆಲ್ಲ ಕೋರ್ಟ್ಗೆ ಹೇಳೋದು ಅದೆಲ್ಲ ನಮ್ಮ ಕೆಲಸ. I have to filter and say, sorry, I am going to say this I am not going to say, or I am going to say this as the first point, this is going to be the last point. It is left to us. That is the role of a senior advocate. If you miss that, then the whole institution is a waste, your client's money is a waste because you've got to pay 2 lawyers. There should be value addition, not duplication.
ಸರ್, ಈ ಹ್ಯೂಮರ್ ಇನ್ ಎ ಕೋರ್ಟ್, ಈಗ ತಾವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋ ಸಂದರ್ಭದಲ್ಲಿ ಕೋರ್ಟಲ್ಲಿ ತುಂಬ ತಮಾಷೆಯ ಪ್ರಸಂಗಗಳು ಆಗ್ತವೆ ಅಂತ ಒಂದೆರಡು ಪ್ರಸಂಗ ನೆನಪು ಮಾಡ್ಬೋದಾ?
Well, it all depends upon circumstances. You see, you cannot say a humor in court is something that you can simply write and recite. So, it happens in court spontaneously. Therefore, if you ask me, please repeat what happened in court, it becomes too artificial. But humor in court is very important. human in court must be in such a manner which will not in any manner bring down the reputation of the institution. And there should be a time limit for everything. You can't keep wasting your time. Anyway, I will tell you one it's humor in court on an adjournment. It happened. It appears a lawyer wanted an adjournment in a case because he did not want to go on before the judge. So he came up and said, "My lord, I want an adjournment in this case." And the judge said, "Why?" "I have forgotten my spectacles. I can't read." Judge also knew that this lawyer was playing the fool and he wants to avoid him. He said, "Don't worry, mister. Take my spectacles. I will listen. You read. So we can go on with the case." The lawyer also was very smart, but he said, "Yes, my lord, please give it to me." He took the judge's spectacles, put it on, and then said, "No, my lord, I still want an adjournment." "Why? You are not able to read it?" "No, I am able to read it, but I am seeing the case from your point of view. I want to see from my point of view."
Because the
Judge's point of view.
spectacles.
ಹಾಗೆ humor in court is important, especially because of the monotony that goes on from morning till evening. ಈಗ ಮೊನ್ನೆ ಒಂದು ಮಾಡ್ತಾ ಇದ್ದೆ ಒಂದು ಕೇಸು. The question was as to how the time that is spent during COVID is saved for the purpose of limitation ಅಂತ.
Oh.
ಅದೇನು ಇದೆಯಲ್ಲ, ಜಡ್ಜ್ಮೆಂಟ್, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ, ಈ ಥರ ಈ ಪೀರಿಯಡಲ್ಲಿ ಮಾಡಿದ್ರೆ ಅದನ್ನು ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿ ಅದೆಲ್ಲ ಮಾಡೋದು. ಸೊ ದೆನ್ ಐ ವಾಸ್ ಟೆಲಿಂಗ್ ದ ಜಡ್ಜ್, ಐ ಸೆಡ್, "ಮೈ ಲಾರ್ಡ್, ದ ಓನ್ಲಿ ಥಿಂಗ್ that stopped during COVID was limitation for the purpose of litigation, but all of us got old. That didn't stop."
Let us stop.
So I said, that didn't stop. Some people got prematurely old also. So limitation was stopped only for the purpose of litigation, not for the purpose of anything else. COVID had no effect. COVID, on the contrary, had an adverse effect. You see, humor in court is very important. There should be healthy humor. You should never ever have a humor at the cost of the institution.
Correct.
Don't make fun of the institution. Don't make fun of the institution.
ಸರ್, ತಾವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿರೋ ಕೇಸುಗಳಲ್ಲಿ ಸಾವಿರಾರು ಕೇಸುಗಳಲ್ಲಿ ತುಂಬ ಕೇಸುಗಳು ರಿಪೋರ್ಟ್ ಆಗಿದ್ದಾವೆ ಅಂತ ಒಂದು ಕೆಲವು ಇಂಪಾರ್ಟೆಂಟ್ ಅನಿಸುವಂತಹ
ಅದು difficult to say.
Which case
see,
is
it's difficult to say. Each case has its own nuances, and there isn't that type of a case you say this is more important than this. Each case is as important as the other. Therefore, I do not think that your question is capable of a direct answer that these are the cases.
1, 2, 3, 4, 5.
No. Every case is as important as the other because of the point of view of the client. He doesn't care whether your case is reported or not reported. He is interested in whether you have done your job well. So, if you ask me, if you ask me which is an important case, every case which I have read well is an important case. Otherwise, it isn't.
Because the importance should be given, the same importance should be given to all
every
the cases.
Every case.
Whichever case comes.
Of course, you see, there are cases where some important constitutional issues have been made. Those are all different types of matters. But from the point of view of the cases that we handle in the high courts, every case is important.
Importance of case doesn't matter who is the client. That doesn't matter.
Whoever, it doesn't matter.
Whoever the client.
For that client, that case is very important. So for us, therefore, to classify a case as an important case, not important case, I don't think a lawyer should do it. Every case is important because it's the client's. The client doesn't care whether you have 10 cases that day, whether you are a busy lawyer. He doesn't care one bit about it. He is rightly so. He is interested in nam case ಮಾಡ್ಕೊಡ್ತಿರೋ.
He is interested in his case only.
He is right.
He is right. Because we are serving.
And if you can't take up his case because you think you have other important cases, please refuse to accept his case. So these important reported cases, I don't attach too much of importance to it.